I will request all of you, please take your seats. We are going to start the proceedings. Suprabhat, good morning, ladies and gentlemen. We extend our heartiest welcome to all of you in the second day's proceedings of the National Conference on Mediation by Samadhan, Delhi High Court Mediation and Conciliation Center. Today, we are going to start the proceedings with our first session titled Mediation at the Dawn of a Golden Age. Our panelists for this session are Honorable Chief Justice Singapore, Mr. Justice Sundaresh Menon, and Honorable Judge Supreme Court of India, and also Executive Chairman NALSA, and Chairman MCPC, Mr. Justice Sanjay Kishan Kaul. Let's welcome both the panelists, Honorable learned panelists on the stage. Honorable Chief Justice Singapore, Mr. Justice Sundaresh Menon, and Honorable Judge Supreme Court of India, Mr. Justice Sanjay Kishan Kaul ji. And the moderators in this session will be Justice Manmohan, Judge, Delhi High Court, and Chairman, Overseeing Committee, and Advocate Sadhana Ram, Secretary, to welcome Chief Justice of Singapore, Mr. Justice Sundaresh Menon.
Thank you so much.
With a huge round of applause, of course, he has come all the way from Singapore to attend this seminar and particularly this session, and will be contributing a lot in this session by his presence.
Thank you.
And I will request Justice Manmeet, Judge, Delhi High Court, to honor and to felicitate Mr. Justice Sanjay Kishan Kaul, Honorable Judge, Supreme Court of India, and Executive Chairman NALSA, and Chairman MCPC. We welcome you, sir.
Thank you.
Ladies and gentlemen, the moderators will be introducing the panelists as per the schedule and requirement. But let me have the honor to introduce the learned moderators in this session. Justice Manmohan was enrolled as an advocate with the Bar Council of Delhi in 1987. He was designated as senior advocate in 2003. Elevated as an additional judge of Delhi High Court of Delhi in 2008, and appointed as a permanent judge in 2009. He has delivered a number of significant judgments concerning rights of economically weaker sections to get support in case of chronic and critical medical conditions, and also the right of every child to access digital education during the COVID-19 pandemic. We welcome Honorable Justice Manmohan, who is present here to moderate the session. The second moderator in this session is Sadhana Ramachandranji, who is an advocate on record of the Supreme Court and has almost completed 42 years at the bar. She is a mediator for over 14 years. She has conducted mediations in all genres of disputes, including matrimonial and family, contractual, commercial, industrial, and intellectual property. She is a member of Organizing Committee of Samadhan, the Delhi High Court's Mediation Center, and its former organizing secretary. For her work in mediation, she has received an award by the Bar Association of India, and many more awards she has received. So we welcome all the guest panelists and moderators on the stage, and I will request Justice Manmohan to initiate the proceedings of this session.
Good morning, ladies and gentlemen. It's my privilege to introduce the Chief Justice of Singapore, Mr. Justice Sundaresh Menon. But there is one difficulty or issue. How do you introduce a person who's so well known and so well revered in Delhi? He is the youngest Chief Justice of Singapore. He has a unique distinction of having served as the Attorney General and as the Chief Justice of Singapore. In fact, his speeches are well received all over the world, and they are often quoted in judgments. I myself have referred to some of his speeches in my judgment, especially the Vodafone one, where I had an occasion to deal with the bilateral investment promotion disputes, and I quoted from his speech. He's a thinker, and he's a man of convictions. He doesn't shy away from making some predictions, as it were. For instance, he was one of the first lawyers who felt that international commercial arbitration had a huge scope. And then when he became the Chief Justice of Singapore, I think he gave a huge push to the commercial court. And he felt that the international commercial disputes needed to be resolved in a commercial court. And he gave a huge fill-up to that. And he was of the view that that was the appropriate dispute resolution mechanism. Now he's predicting that mediation is the most appropriate dispute resolution mechanism as of today. In fact, the theme has been selected at his instance around the topic that he suggested that he would speak on. So we are honored to have him, and we look forward to hearing from him.
Thank you.
Thank you very much for coming.
Thank you. Do I go now?
Just to introduce Justice Scott. Go ahead, go ahead.
No, I will speak.
You want to be introduced, Justice?
Okay. Again, how does one introduce Justice Kaul? He is such a part of all of us. But I would like to make a couple of points about him as a judicial leader wherever he has been. Whether it's the Delhi High Court, whether he was Chief Justice of the Punjab and Haryana High Court, the Chief Justice of Madras High Court, and now as a judge of the Supreme Court. And I think his judicial leadership has shaped judicial institutions, not only the courts where he has adorned the bench, but now NALSAR, MCPC, and all the mediation centers around the country. Justice Kaul has always worn for us mediators his lawyer's robes and stood up and supported us against some strange odds that sometimes we didn't follow, sometimes we didn't understand. But he was there and has been our mentor, our guide, our pillar of strength in our journey, our joint journey in mediation in India. And one of the most significant contributions recently that Justice Kaul made was that he initiated, as part of MCPC, as a member of the MCPC, the drafting of the new mediation bill, and appointed a committee across the country that drafted the bill, and the Supreme Court then sent the bill to Parliament. I think that out-of-the-box thinking is what makes Justice Kaul what he is. Sir, we are so happy to have you yet again, and we look forward to your comments, your perceptions, and your response to Justice Menon.
May I request Justice Menon to now take the stage?
Yes, thank you.
The Honourable Mr. Justice Sanjay Kishan Kaul and the Honourable members of the Indian Judiciary, distinguished guests, ladies and gentlemen, a very good morning to all of you. And thank you, Justice Manmohan, for those very, very generous introductory remarks. I really am delighted to be back in India so soon after my last visit. And I thank my friend, Justice Sanjay Kaul, as well as the Chief Justice and judges of the Delhi High Court, for inviting me to join you at this plenary session. I'm honored to have this opportunity to share with you my perspectives on the immense potential of mediation to transform the face of dispute resolution, and to speak to you about Singapore's experience in this area. Dispute resolution is coming to be seen today as resting on three principal foundations: litigation, arbitration, and mediation. Whereas the amicable resolution of disputes has historically played an important part in our societies, the rise to eminence of mediation as a key contributor to the rule of law and as part of our justice systems is a quite modern phenomenon. In my remarks today, I will begin with the suggestion that mediation's place in today's dispute resolution landscape should not be understated on account of its recency. because mediation offers some unique value propositions when compared to the alternatives. I will go on to explain why I consider that we are at the dawn of a golden age for mediation, because its foremost challenge, which is that of enforceability, is being swept away by the Singapore Convention on Mediation. And I will then conclude by offering some suggestions as to what we should all do to usher in this golden age for mediation. All of us, I think, would have grown up at a time when dispute resolution was understood to be synonymous with litigation and with arbitration. At their core, these are both adjudicative approaches to dispute resolution. They involve a neutral and impartial third party pronouncing upon questions of ultimate truth and applying the legal analysis to determine the rights and wrongs of a case after making factual findings and then applying the law to them. While the practice of dispute resolution has undoubtedly seen many changes over the past decades, some of the most prominent of these, such as the growth of international commercial arbitration and investor-state dispute settlement, and the more recent rise of international commercial courts, have all been built upon the same foundations of the adjudicative process. Arbitration and litigation each have their merits and demerits, but there is also a growing recognition of the reality that purely adjudicative approaches to dispute resolution are bedeviled by certain challenges. Some of these are long-standing, while others are new, emerging, and in some respects worsening. The first and most obvious of these is the ever-increasing level of the time and cost that is entailed in the adjudicative process. This is rooted in the vital need for fairness in any adjudicative process, which in turn necessitates extensive procedural formalities and an often protracted series of interlocutory steps that must be taken to get a case ready for hearing. This cost of ensuring procedural fairness scales up steadily with the size and complexity of the dispute. One estimate has put the total cost of litigation conducted by Fortune 500 companies at as much as 1/3 of the company's after-tax profits. This is an issue that plagues litigation and perhaps to an even greater extent, international commercial arbitration, where costs awards in the largest cases routinely exceed US $10 million. Indeed, surveys show that international arbitration practitioners and users consider cost to be by far the worst characteristic of international arbitration. This challenge is exacerbated by a more recent phenomenon that I have referred to as the complexification of disputes. This refers to the growing complexity of disputes, which manifests in two principal ways: technical and evidential complexity. Technical complexity arises from the increasing amount of domain-specific scientific and technical knowledge that adjudicators need to grapple with. In a world where contracts are entered into using algorithms and vehicles are starting to drive themselves, even relatively simple disputes can involve an inquiry into complex technical facts. At the same time, the evidential complexity of disputes has exploded because we now rely heavily on digital communications in every aspect of our lives. This means that vast quantities of data are generated even in a quite modest transaction, resulting in volumes of documentary evidence that tribunals, lawyers, and parties will all have to sift through and digest if they are to come to grips with any dispute. Complexification will require ever-increasing amounts of time and cost to be expended in the search for justice, that uses a purely adjudicative approach to dispute resolution. And beyond this, complexification of disputes gives rise to the very real possibility of disputes becoming so large and so complex that a human adjudicator may not even be mentally capable of absorbing and processing all of the material. Let me give you one example. In a construction arbitration, the claimant was said to have asserted more than 120,000 events that impacted the schedule of the project, while the respondent counterclaimed literally for thousands of defects. In such a case, let's be honest, it would be virtually impossible for a human trier of fact to give each disputed fact the sort of attention that would typically be needed using our conventional processes to make a sound determination of the parties' rights. This seems to cry out for an approach that would radically downsize and simplify the issues in dispute. But an adjudicator would be hard-pressed to achieve this if either of the parties were to insist on advancing and trying its claims in the conventional way. This leads me to the next set of challenges that bedevil adjudicative methods of dispute resolution, and that is the lack of control over process and outcome. This is perhaps most evident in litigation because procedural and evidential rules in litigation were devised in a different time and with a very different understanding of the likely scale of typical disputes. And they were designed to ensure scrupulous fairness in cases where the parties were typically locked in a hostile stance towards each other. In such cases, the process is usually binary, producing a winner and a loser. And it incentivizes the deployment of procedural skirmishes to achieve tactical victories. While arbitration was once thought to offer a better process characterized by procedural flexibility and proportionality, it too has become dogged by its own challenges. And this is not a recent phenomenon. Nearly 35 years ago, Lord Mustell wryly observed that international commercial arbitration might be acquiring, in his words, all the elephantine laboriousness of an action in court without the saving grace of the exasperated judge's power to bang together the heads of recalcitrant parties. In more recent times, I have spoken about the phenomenon of due process paranoia. This describes the widely observed trend of disgruntled parties contriving allegations of breaches of natural justice in an effort to try to secure the setting aside of the arbitral award, which would have been made after the expenditure of millions of dollars. It has been suggested that due process paranoia has caused arbitrators to become overly cautious and to indulge the dilatory tactics of parties for fear of their awards being set aside. Accompanying this lack of control over process in adjudicative processes is the parties' lack of control over outcomes. Simply put, all the power over the outcome is vested in the hands of the adjudicator, who will be assisted by counsel. But the adjudicator's assessment will turn on issues which are designated as having legal significance by the dictates of legal doctrine. These will often be narrow issues which may not correspond at all to the parties' real concerns when they entered into the transaction in the first place. When a dispute arises, the parties' real interests usually concern finding a workable plan forward, remedying the problems they have encountered, and maintaining and repairing working relationships. On the other hand, an adjudicative approach to dispute resolution, with its attention to scrutinizing and allocating fault, places a heavy emphasis on the past, gives only secondary importance to the present, and pays very little if any, attention to the future. The challenges that I've outlined can seem almost insurmountable if we conceive of dispute resolution as being focused single-mindedly on a search for the truth between warring parties. But as I have argued in the context of complexification, it is no longer feasible or desirable to assume that justice requires in every case a full and exhaustive determination of the facts or of the legal rights and wrongs. First, this will not always even be possible to achieve in the kinds of hyper-complex disputes that we're beginning to see today. And second, the devotion of the required level of resources to this exercise in some disputes comes at the expense of other parts of the justice system, simply because our judicial resources are finite. And potentially, this directly impacts the ability of many others to access the justice system at all. It follows that this endeavor of the exhaustive search for the truth comes at a heavy societal cost that we need to keep very much in mind. And third, and most importantly, it is often not what the parties themselves really want, as I've just explained. We should therefore be very careful not to equate dispute resolution with adjudication. Nor should we think that adjudication is the primary or default or preferred means of dispute resolution. Something that the label alternative dispute resolution, which is typically applied to non-adjudicative modes such as mediation, tends to reinforce. Instead, we should recognize that dispute resolution comes in multiple co-equal forms, each with its own role and value. Both adjudicative processes such as litigation and arbitration, and non-adjudicative, non-rights-based approaches such as mediation. This would open the way for us to see mediation as an equally viable option for dispute resolution that offers a neat answer to many of the problems that inhere in the adoption of purely adjudicative approaches. First, mediation has obvious advantages in terms of time and cost. The Singapore Mediation Center, or SMC, reports that 90% of its successful mediations take no longer than 1 day. One can immediately see the immense potential of mediation to alleviate access to justice concerns. Simply put, many disputants may be able to make use of mediation to address the legal needs or challenges that would otherwise have gone unaddressed altogether because it was not possible or not economically viable to expend the time and cost of going through an exhaustive adjudicative process. Relatedly, mediation is much more accessible to lay litigants because the kinds of concerns that are typically ventilated in mediation are precisely those that ordinary people care about in a dispute, without their having to go through the alien and difficult task of trying to translate and frame those concerns in terms of legal issues and arguments. And even if the dispute is not ultimately settled after mediation, going through the process can often narrow the issues and lead to a much clearer focus on what really separates the parties when they proceed to an adjudicative process. Second, mediation preserves the parties' control over process and outcome, since the mediation process is driven by the concerns that the parties express to the mediator and to each other. And the outcome of the mediation is shaped by the parties themselves, albeit with the assistance of the mediator. As a result, mediation has proven to be highly effective. The SMC, for instance, reports a success rate of upwards of 70% of cases that are referred to them for mediation. It bears mentioning that success in a mediation, by definition, involves a resolution that all the parties are reasonably satisfied with. And this, therefore, goes beyond simply resolving the dispute at hand, but translates to a higher chance of compliance and of preserving the parties' relationship. In Singapore, we have seen mediation's versatility and success across all areas of dispute resolution. Besides the SMC, which provides a broad-based generalist mediation service, we have used mediation in Singapore in a number of specialized areas. Family justice is the quintessential example of when mediation should very often be the first port of call to resolve the dispute of the parties. Although the spousal relationship will usually have broken down by the time the parties seek recourse from the family justice system, there will be a strong, persisting interest in maintaining at least a functional relationship between them to enable them to deal with the ancillary issues that invariably will arise in the wake of a divorce. And this will continue well into the future in cases where the couple has minor children. It is therefore important to focus on repairing the relationship with an eye towards the future, even as the parties seek to separate from their unhappy past. In addition, the process needs to be holistic because the legal issues in family justice will invariably be undergirded by broader, non-legal questions. Mediation is the mode of dispute resolution that addresses all of these needs. And recognizing this, our family justice system has placed increasing emphasis on its use, especially where there are children involved. Thus, between 1996 and 2014, the law was progressively amended and today requires all divorcing couples with children under the age of 21 to undergo mandatory mediation or counseling, and to empower family judges to order the parties to undergo mediation. In recent years, we have sought to meet the need for a restorative, holistic, and forward-looking approach to family justice by integrating all the aspects of our family justice system under the overarching philosophy that we know as therapeutic justice. Just think of the concept. When we apply therapeutic justice, problem solving rather than fault finding becomes the core focus and concern of the justice system. It therefore emphasizes multidisciplinary approaches to family dispute resolution by addressing the core underlying problems. And this will be accompanied by the use of mediation and conciliation. It is not difficult to appreciate how a similar problem-solving approach could be useful in our efforts to resolve disputes within the wider community. In 1998, the Community Mediation Center was set up in Singapore to address this need. Today, claims filed in our community disputes resolution tribunals may be referred to the Center for Compulsory Mediation. The same powers also apply to private prosecutions or magistrates' complaints, which are often rooted in community disputes as well. And actually, this is something we're all familiar with because it harks back to the age-old practice in almost every civilization of having elders and community members mediate and resolve disputes, including, for instance, the panchayat system in rural India. Another area where the preservation of the parties' relationships in the face of a dispute can be of great benefit is in employment disputes. In 2011, the Singapore government, the trade unions, and the employers' federations set up the tripartite mediation framework to assist with the resolution of employment disputes involving professionals, managers, and executives. The Employment Claims Tribunal was launched in 2017, and the parties to employment disputes are now required to undergo mandatory mediation at the Tripartite Alliance for Dispute Management before employment-related claims can be filed before the tribunal. And finally, we have also recognized that some types of commercial disputes can especially benefit from specialist mediation services. For instance, this can be especially true of construction disputes, which often emerge during the course of a project that can be expected to last for some time. In such a context, there will usually be a strong interest in preserving the relationship between the parties, and many construction disputes are complex and highly technical and therefore may benefit from mediation by domain experts. To fill this need, the Singapore Construction Mediation Center was established in 2019, featuring a panel of mediators with deep construction expertise. With all these advantages and a commendable track record of success across many domains of dispute resolution, it might seem surprising that mediation remains far less prevalent as a mode of dispute resolution today when compared to litigation and arbitration. In 2019, a survey of legal professionals that was conducted by the Singapore Academy of Law found that only 5% of respondents cited mediation as their preferred means of resolving disputes. As the respondents to the survey made clear, litigation and arbitration remain the preeminent modes of dispute resolution, principally because of concerns over enforceability. The long-held view was that even if a mediation proved successful, the parties might still have to resort to litigation to enforce the mediated settlement agreement if it was not subsequently complied with. In that sense, the parties could be back to square one, or worse, be out of pocket twice. First, for the cost of mediation, and then of litigation. This concern becomes heightened where the dispute is transnational in nature. It may be surprising to some of us that a similar concern once existed in the context of international commercial arbitration, but that has long been eliminated with the nearly universal adoption of the New York Convention, which has enabled the simple and effective enforcement of arbitral awards across borders. Meanwhile, when it comes to international commercial litigation, foreign judgments can be enforced relatively easily under the domestic laws of most jurisdictions, and efforts to supplement this through the harmonization of laws internationally and the development of the convention are well underway. It is for this reason that the Singapore Convention on Mediation has been described as the missing third piece in the framework for international dispute resolution. Modeled after the New York Convention, the Singapore Convention shares the brevity and clarity of its approach. It applies to settlement agreements that result from the mediation of commercial disputes, which are international in nature with reference to the parties' place of business or the nature of the settlement agreement. Article 3 sets out the primary obligation under the Convention, which requires states parties to enforce such settlement agreements. And like the New York Convention, the Singapore Convention sets out in Article 5 an exclusive and limited set of grounds for the refusal of enforcement, thereby setting a ceiling on the scope for challenges against a settlement agreement. These include grounds familiar from the New York Convention, such as the incapacity of one of the parties, or the nullity or inoperability of the settlement agreement, or concerns based on the public policy of the state where enforcement is sought. In addition, there are very limited grounds for challenges based on the way the mediation was conducted, notably where there has been what is described as a serious breach by the mediator of standards applicable to the mediator of the mediation, but for which the resisting party would not have entered into the settlement agreement. It is clear that there was considerable appetite for the development of such an instrument to meet the needs of the international commercial and dispute resolution community. The UNCITRAL working group was able to complete its work on the Singapore Convention within an incredibly short span of 3 years. And on 7th August 2019, the day the convention opened for signature, 46 countries, including India, China, and the United States, signed the convention. This was among the highest number of first-day signatories of any UN trade convention. The convention entered into force just a year later on 12th September 2020. After Singapore signed the convention, our parliament promptly passed the Singapore Convention on Mediation Act 2020 in preparation for our ratification of the convention. In a reflection of how easy it was to implement it, the convention is given effect in the act either by direct reference to the provisions of the convention or by substantially reproducing its provisions. A short set of procedural rules were also enacted to provide the mechanism for applications to be made to the General Division of the High Court to record an international settlement agreement as an order of court for the purposes of its recognition and enforcement in Singapore. The adoption of the Singapore Convention goes a long way towards tackling another related obstacle standing in the way of the more widespread adoption of mediation, and that is the assurance of its legitimacy. This stemmed from perceptions of the level of practical difficulties that would be encountered in mediation. The UNCITRAL working group on the Singapore Convention was told by users that mediation lacked the, quote, stamp of international legitimacy that had been afforded to international commercial arbitration by the New York Convention, and that this was one of the reasons that commercial parties found it difficult to convince their business partners to engage in mediation as a primary option for the resolution of their disputes. By directly addressing the real and perceived challenges of enforcing mediated settlement agreements, the Singapore Convention showcases the legitimacy of international commercial mediation, and this in turn is likely to have a halo effect in securing the legitimacy of mediation as a form of dispute resolution in general, because the practices and attitudes of commercial actors on the transnational plane will inevitably spill over to their domestic dealings. With the coming into force of the Singapore Convention, I believe that we are now witnessing the dawn of mediation's golden age. I would like to come to the close of my address by offering 3 suggestions for ushering in this golden age, starting from the specific and moving towards the general, and in particular, the transnational system of commercial dispute resolution as a whole. First, and most simply, we should raise awareness of the immense importance of the convention and encourage its adoption by states and its use by commercial parties. At present, the convention has 55 signatories and 11 states parties. We therefore have some way to go as we aspire towards a universal enforcement mechanism for international commercial mediation, similar to that which international commercial arbitration enjoys today. This process will naturally take some time. After all, the New York Convention has had a 60-year head start. But the Singapore Convention will not take as long. It has already generated considerable momentum, and this is seen most recently in the fact that just this past month, the UK government committed to signing and ratifying the convention following consultations that were held in 2019 and 2022. Second, we should pursue excellence in the practice of mediation. This would boost the reputation and legitimacy that mediation enjoys. To do this, we should strive to professionalize the practice of mediation and promote the development and recognition of standards for the training and accreditation of mediators. This should start from the very early stages of professional training for lawyers so that new practitioners are socialized to the importance of mediation. In Singapore, we offer a module on mediation as part of the bar course. With the implementation of the new syllabus for the bar course starting from 2024, we expect to make an introduction to mediation and mediation advocacy a part of the compulsory dispute resolution practice module. This will expose young lawyers to mediation from the very beginning of their legal practice, so that they will come to see it as a natural and indeed necessary part of the suite of dispute resolution options available to them. In time to come, we can expect all Singapore lawyers to be acquainted with the value proposition of mediation and how it works. But for legal professionals who want to practice mediation as a mainstay of their work, further training and accreditation should be provided. Mediation calls on different skills from litigation and arbitration. Whereas a judge can take up the role of an arbitrator with relative ease, and advocates can apply similar skills in litigation and arbitration, the same cannot be said of mediation. We need to recognize that. It is for this reason that we saw the need to entrust the setting of standards and the provision of accreditation for mediators to a professional body. Today, that role is fulfilled by the Singapore International Mediation Institute, or SIMI. SIMI features a tiered accreditation structure and systematically takes into account user feedback as a requirement for progression to higher tiers. Members of the highest tier, known as SIMI certified mediators, can apply for cross-certification with the International Mediation Institute, which is an internationally recognized standards body. Third, we should enhance collaboration between judges, arbitrators, and mediators. This is because commercial dispute resolution today should not be compartmentalized into these different modes. Instead, litigation, arbitration, and mediation should come to be seen and understood as key components of the system of international commercial dispute resolution, with disputes flowing between them as the need arises. Collaboration and exchange within this ecosystem will therefore be essential for the effective resolution of disputes, and this can arise at a number of levels. First, the judiciary's support for and understanding of mediation will be essential because judges can play a highly beneficial role if they were to divert appropriate cases towards mediation. A good example of this comes from the field of insolvency and restructuring. In complex insolvencies where there are multiple claims of a similar nature, it will often be viable and beneficial to engage in what is known as similar claims mediation. That was the experience of Judge James Peck, who presided over the insolvency of Lehman Brothers. He recounted that the multitude of claims would have been overwhelming and well beyond the capacity of any single judge had it not been for the mediation protocol that he adopted, which yielded settlements worth billions of dollars. Similarly, in cases involving the development of a restructuring plan, the use of plan mediation might allow the reaching of a consensus in otherwise intractable proceedings. A judge astute about such opportunities can encourage the parties to explore these options in appropriate cases. Second, commercial courts will have a responsibility for setting and enforcing standards in international commercial mediation, just as they do in international arbitration. And this is even more the case because Article 5 of the Singapore Convention, as I mentioned, allows parties to seek the ruling of the courts as to whether there has been a serious breach of standards by the mediator. Judges will not be in a position to articulate and rule on such standards without considerable familiarity with the practice of mediation. Further, under the Singapore Convention, there is no notion of the seat of the mediation, unlike the concept of the seat of the arbitration. The jurisdiction where mediation takes place, therefore, need not be the natural port of call for such challenges. Instead, these challenges will be raised in whichever jurisdiction the settlement is sought to be enforced. Commercial courts must therefore be prepared to deal with challenges that concern the standards applicable to a mediator or mediation acting anywhere in the world. This clearly points to the need for judges to be aware of the nuances of mediation practice and standards. And finally, the advent of integrated dispute resolution models such as multi-tier dispute resolution clauses and dispute boards create a further opportunity for synergy between adjudicators and mediators. Under such models, various techniques based on mediation are used either to dispose of disputes or to downsize and contain them so that what goes to adjudication is refined and limited. Each adjudicator or mediator presiding over a stage of the dispute holds only a piece of the puzzle, and they will need to be distinctly aware of how their roles fit together in the management of the dispute or the project as a whole. Ladies and gentlemen, let me conclude by taking a step back to see where we stand today. Commercial litigation in its modern form is the product of centuries of evolution and experience. While the dramatic rise of international commercial arbitration has taken place over the past 60 years or so, our goal, I suggest, should be to bring mediation to a similar, if not higher level of prevalence as these adjudicative modes of dispute resolution, and to secure for mediation the reputation and legitimacy that international commercial courts and arbitration institutions enjoy today. This may seem like a daunting task, but in today's world, where the drawbacks of adjudicative processes are difficult to ignore and the benefits of mediation are becoming increasingly obvious, I believe mediation will require a much shorter runway to achieve this. An important reason we should have confidence in this endeavor is the Singapore Convention, which institutionalizes the important role of mediation. With its current trajectory, its widespread adoption may be achievable within the span of years rather than decades. I suggest, therefore, that the path forward is clear. If we vigorously promote the Convention, champion excellence in the practice of mediation, and encourage collaboration across the different components of the transnational system of commercial dispute resolution, I believe that the dawn we are now witnessing will mark the beginning of a golden age for mediation. And this, in turn, promises a brighter future for all of us by promoting better outcomes in the resolution of disputes, greater confidence in doing business across borders, and enhanced access to justice. Thank you very much for your attention. Thank you.
May I now request Justice Call to share his views? Very comprehensive.
Very good morning to all of you. I'm very pleased to share this platform with Mr. Sundaresh Menon, who's been kind enough to accept our invitation and join us here. I think rightly so, yesterday in an informal discussion, he was labeled as a judicial rock star. Sadhna, Mrs. Manmohan, senior mediators, some of them from whom I have learned mediation, my brother judges, sisters, fellow mediators. Conflicts are inevitable in any society. When and how they arise cannot be controlled. However, what can be controlled is the way people choose to resolve these conflicts. There are many ways in which conflicts can be resolved. Conventional and traditional methods such as litigation and arbitration, which require parties to follow orders, pronounced by a neutral third party, or slightly a non-conventional way like mediation or negotiation, where parties come together to resolve the disputes amicably. In my experience of over 40 years in this legal profession, I believe that whenever and wherever possible, solutions of any conflict should flow from the parties themselves. Alternative dispute resolution methods are often commended for being more time and cost efficient, voluntary, and confidential. While all that is true, I feel the most important advantage is their ability to maintain a healthy relationship. In my opinion, talented lawyers and favorable precedents may help parties win a case. But in the process, the parties lose out on the important personal or commercial relationships. Hence, when a party shows inclination towards resolution through the non-conventional method, or if I may say so, the non-confrontational methods, they already take a step towards working a relationship that may have turned sour temporarily. Collaboration is a very important part, both in commercial and personal disputes. I often give some examples which I think are seminal in their cases. And one such example of what happened in Justice Sikri's court, where a dispute between a well-known brand manufacturing jeans and a person who had infringed the trademark came to be heard, and he found there was an element of mediation possible. In trademark matters, dilution of a trademark is a very important principle. And when this issue was raised that, look, they're very differently priced products. How do they, compete with each other? What was urged on behalf of the plaintiff was that the quality is so good that it can match the quality of what is being produced by the international brand. From there, where it was a dispute between an infringer and a well-known brand, possibly it's in Ludhiana, I think, if I remember correctly, that the dispute arose from. It was found that the manufacturers were in need of some good person, and the company, which was the international trade company, decided to source its products from them. So from an infringer and owner relationship, you had a business collaborative model come into place. How can this ever happen in a litigative process where damages would be the award, injunction would be the natural consequence? But the business collaborative process, which Justice Menon also said, would not take place in a normal litigative model. So this conference is really a celebration of one such non-conventional method, which is the mediation. It is often said that mediation has been a part of India's ethos, form of panchayats in India, which are akin to modern-day mediations where a neutral party, usually the elders of the village, aimed at resolving disputes for welfare of the people, while maintaining good relations and harmony among disputants. I slightly disagree with this concept. I think in the panchayat systems, the parties had a social compulsion, and in Indian context, that's an important aspect. They didn't have the freedom to choose the solutions. And it was, in a sense, a third party and elder imposing the view which they felt was best for both the parties. In that sense, the current mediation process is more evolved as the decision solutions emerge from the parties and not per se dictated by mediators. India's constant support towards ADR can be seen through the positive actions taken by the legislature and the judiciary in spheres of arbitration. And I would not get into more depths, but saying that from this regime of arbitration, which required fine-tuning in India and was fine-tuned, the concept of how mediation moves this way, as was being emphasized, is of great significance. Let me say, as a judge, I often find a great satisfaction if parties agree between themselves, than possibly writing some very great nuance of law, which may be praised for its judicial interpretation. I remember once a very old suit which came up before me, And Mr. Chandiok, who has been one of the leading mediators, was one of the counsels, and I told him that why don't you make an endeavor for a solution. We found that parties were spread all over the country. It was a 30 years old suit. And we said, okay, on one day, every party will be here in India before the court. We made arrangements, all of them arrived. They were referred to mediation. And in about 2 weeks, they came back. We had made sure they stay in India for some time with a solution. When I was recording the settlement, one of them raised his hands to say something. So, something I've learned in mediation, let parties sometimes have a say to understand what they're saying, even in courts. So, though the lawyer is trying to intercede, I said, no, let him say what he wants. He said, I just wanted to say thank you, because for so many years we have been sitting in different parts of the country, not having the time to resolve this dispute. I honestly tell you, I valued the thank you more than any judgment I have written, because it brings to an end that dispute within that family. The endeavors of insertion of Section 89 in the Civil Procedure Code and the development of alternative forums by judicial interpretations require a lot of ground level work for it to be made. We've had some great success stories. The Samadhan is one of them, in Bangalore, in Chennai, many other places. But a lot more needs to be done if we are going to take mediation at the grassroots level. And if I may say so, one of the concerns of the authorities in the mediation bill is that how will it work at the grassroots level if you have a compulsory pre-litigation mediation? Are we ready for it? Are there enough mediators for it? Will the parties accept it? And in some way, this mediation bill, as was being said, very promptly adopted in Singapore, we are still at a stage of debating it, though it was a very, very unusual case where the Supreme Court, MCPC itself got into the job during the COVID times of gathering all the mediators together and asking them to create a draft bill in consultation with experts from Singapore, US, UK, etc. And we sent it to the government as a suggestion, because we thought a time had come for mediation to play a role. Even beyond these statutes, the judges try to refer appropriate matters to mediation, depending on the questions raised, the competing interest of the parties, the nature of relationship. In my experience, I have noticed family and commercial disputes are more receptive to such an approach, as there is an enhanced focus on maintaining relationship during and after the resolution of the conflict, which often become impossible once the parties have been through a tedious adversarial court process. In India, there are a lot of family businesses involved. So commerce and personal relationships are interlinked. And Sriram Panchu is here. One of the very strong battle which was being fought in the Madras High Court between the fathers and the sons. It is the mediation only which could resolve an unconventional method to resolve the dispute. It could not have been envisaged that as a solution to a business dispute, one of the sons who was on a different page, some new project gets created for him to handle that away from the family disputes. That's the solution I'm saying which emerged out of it. How will the courts get into this and come up with a solution? Cases of constitutional importance, legal interpretation, and public interest still may require to be processed through the standard format of litigation. The steady trend in favor of mediation has led to increase in the mediation facilities, and we are witness to this in the high courts and district courts at every level, with setting up of now ADR centers along with the courts. The conflict resolution method must, however, be in sync with the times. And this continuing working out and out-of-the-box methodology is a thinking process which I believe must continue. Traditionally, courtrooms were adorned with these black robes, finding their way between piles of files to make effective legal arguments. It had its own charm, and we've all been through it. But when the pandemic hit, our system was brought to a halt. We were introduced to something which was different. Sitting on the screen and seeing a lawyer at a distance of 1 feet is different from seeing a lawyer in court. And similarly, obviously from the lawyer side also, this was so. This has created a lot of infrastructure for both the court And this is what started the e-mediation process itself also. Virtual hearing formats are today a supplement to whatever is there apart from the court systems. And the mediation process, in my belief earlier, I used to always feel that the personal hearing gives the opportunity for interaction into the parties, which is far better than a virtual system. I still believe mediation is better if it is possible to have it, because the nuance of personal interaction are different. But in a lot of international commercial disputes, the feasibility of having all the parties at one go, the expense involved of it itself creates a problem. Therefore, the e-mediation systems is something which has caught on over a period of time. And I believe that both systems, like in court systems, will continue. This would be so of this also. When we talk about thinking differently, trying to work out solutions, one example I can give is of an out-of-box solution sometimes emerging is that there is a system of early neutral evaluation, which is a non-binding mediation. The only difference is that it takes some element of a court proceeding, as both the sides make a summary presentation, and the mediator retires to his chambers to come up with what he thinks would be a result if the parties went into litigation. And that helps parties at times in assess and thereafter carry on mediation further. So it's the first stage of mediation. That's why it was referred to as early neutral evaluation. I was faced with a case where the parties were referred to mediation to an experienced mediator, senior mediator, who was a trainer also in here, present before us. That one dispute had many ramifications of disputes. Those ramifications of disputes were also brought before the mediator. Interestingly, all other disputes got resolved, but the main dispute could not be resolved, and it came back to the court. So an out-of-box thought occurred to me that if these people have so much faith in these mediators to resolve the remaining disputes, can we have a E&E system, though in a reverse way, an early neutral evaluation? It's a late neutral evaluation in that sense. And let them go to the two mediators who will tell them that if they go to litigation for these disputes, what is the possibility of the party's success or failure rate? I don't know what happened, but I thought it was a good method arising from a faith in the mediator of the parties at hand. We are still awaiting the mediation bill, as I said, in this process, and that's something which has troubled us. And yesterday, when the Attorney General was here, I appealed to him that something should be done, because we have been a signatory to the Singapore Convention as one of the initial signatories for the last many years now, almost 3 years. The option of working out, as Justice Menon said, of a confabulation of litigation, mediation, arbitration is the need of the day. The idea is to find a solution to the problem. And that solution is, the focus should be the litigant. Expensive litigation is not something the litigant looks for. There will be different perspectives between the litigants. But he is looking to a solution. Delay is not something which he wants, and which is very German in India. And therefore, he is not concerned with the niceties of the process so long as he finds a solution. I would also like to move to something else, which is a lesser discussed topic, which is the role of mediation in upholding the rule of law. As every student of law is aware, rule of law is rather a nebulous concept. Yet we have Chief Justice Marshall's famous formulation in Marbury versus Madison that R is a government of laws and not of men. This points towards the rule of law as a doctrine concerning the supremacy of rules over whims and fancies of individuals and institutions. The rule of law is thus deeply connected to the idea of stability, equality, and ultimately individual freedoms guaranteed by law. So where does mediation fit in with a society professing to be governed by the rule of law? Traditionally, conceptions of rule of law have always been applied to framework of formal judicial procedures. In this regard, it is emphasized that to truly give effect to the rule of law, the court's pronouncements must be consistent and they must be strictly abide by the citizenry. However, the concept of mediation not only allows us to broaden our understanding of the rule of law, it grants a richer hue to the concepts as a whole. It is well known that mediation has great ramifications upon the judicial process. It can increase efficiency by resolving disputes before they reach the courtroom. It can lessen the number of tiers of scrutiny which will happen. And this can take away the caseload where the stakes are low or where the question of law is well settled. It can in turn allow courts to focus on more deeply contentious cases that require full alienation. There is, of course, no bright line between these two categories. Of casings require the court's time in cases that may not. However, a successful mediation system carries out this filtering task by its own accord, apart from being what I believe is a superior system to resolve a dispute. Mediation also contributes to the law's legitimacy by resolving cases in a manner that is often more acceptable to the litigants as compared to the often uncompromising hands of the courts. Thus, where there are sensitive issues involved, such as in family disputes, there is a need to interfere externally by way of a court order. Mediation in that sense allows solutions to emerge from within rather than imposing them externally. When individuals feel that the rule has been shaped with their own participation, then they are more likely to comply with it voluntarily. This reduces the cost of compliance, which, as we know, can range from further increased pendency in courts to the increased deployment of law enforcement agencies. In fact, in the Indian context, it is often said that a second round starts after the decree is finalized and the execution starts. And we have all experiences of this. Thus, sustained and disbursed use of mediation has a significant ramifications upon the legal system as a whole. While the benefit of mediation is obvious, the real challenge remains with how we can make mediation success in practice. This is the question that scholars, practitioners, and judges must address together. And I have tremendous confidence in the abilities of those present in this conference to tackle this question head on and make India a mediation-friendly jurisdiction. I would end by giving an illustration, a live illustration of what signifies the difference between this mediation and litigation. And some of you may have in different conferences heard me give this example, related to me by my good friend Justice Nandajog. In Delhi, the Delhi High Court has inside kiosks outside where litigants can go and get some samosas or cold drinks or other aspects. So one litigant who had been the receiving end of a court system went there and asked for a cold coffee. He was by mistake handed over pista milk or something instead. So he asked that person, what did I ask for? He said, cold coffee. What have you given me? He said, mistakenly a pista milk. So he turned to his friend and said, ye pichle janam mein judge hoga. He must be a judge in his last lifetime. Mango kuch ho, deta kuch aur hai. You ask for something else and he gives you something else. That signifies the difference. Thank you, ladies and gentlemen, and Jai Hind.
I think we'll take a few questions. To begin with, Chief Justice Menon, may I ask you, looking back on Singapore's mediation journey from the mid-1990s to the present, what big picture lessons would you think that India can learn from? And what are the things you would have done differently in Singapore in hindsight?
Thank you. Thank you, Justice Manmohan. Let me come to it by touching, sort of looking at narrating a sort of a story of how we got it going. I think the first thing we did, the first place in which we hooked or anchored our commitment to mediation was in the courts. And I think that was a very important part of how mediation grew. And that context itself is important because it was something that came up in the 90s when Singapore was really dealing with a big problem of a backlog of cases. And the Chief Justice at that time, his main job was to try to clear that backlog. And cases were 7-8 years in waiting, and he needed to clear that. So a number of initiatives were tried out, and part of that story was incorporating mediation as a way in which many of these cases could be resolved. And I think that getting the courts involved in the process was a very good idea, because in most systems that we are familiar with, as it is in India and Singapore, the courts sort of hold a preeminent role in the justice system. And getting the courts saying some of the things that we have heard today from Justice Call, from myself, about the value proposition that mediation offers, I think was a huge factor in promoting its legitimacy, its relevance, and its usefulness. And I think that was the first thing. And what we did was we introduced mediation in the context of court-annexed models dealing with certain specific areas. And those areas were most notably in the areas that had the obvious logic, again, that both of us identified. Family disputes, community disputes, these kinds of things. They're the low fruit that you can pluck and straight away see that this actually makes sense, and you don't need a big legal spiel to get the point across. It was very, very obvious. So I think getting the courts behind it, incorporating mediation as part of the justice process was a very important factor. And as part of that, it led to a change in the understanding of what a justice system is. And Justice Call made a point which I completely agree with, and I also have advocated, which is that justice need not be found in a courtroom. You can find justice at the end of the day in many places, and actually the best justice is often found in the parties coming about with a solution that they both want to live with and they both want to move forward with. And that idea of changing our conception of the rule of law, of changing our conception of what it means to get justice, I think was a very important factor, again, in promoting the legitimacy and the growth of mediation. The second point was, I think that what we did was we introduced mediation and incorporated what I would call encouraging tools to encourage the adoption of mediation. We did not, in the beginning, mandate mediation. In the beginning, we did not mandate. Instead, we introduced into rules things like a duty for solicitors to consider alternative methods of dispute resolution, including mediation, to address their mind to it. And then we upped it subsequently to saying parties are encouraged to try mediation, and if a reasonable offer of mediation is made and not accepted, it can be taken into account in the award of costs. So we socialized people towards adoption of mediation as part of the overall dispute resolution in this graduated way, so that they were socialized and they began to see actually there's value in it. And I think the third point was lawyers got involved in mediation almost as a force of circumstance. I mean, I'll tell you my first experience with mediation. I studied mediation as a theory when I went to do my master's in the States in 1990. And it was very interesting because I studied under Professor Frank Sander, who was one of the world's leading experts and proponents of mediation. But then when I came back, it was never part of our practice until 3-4 years later when we were in the midst of clearing the backlog. And I remember being called down because in the attempt to clear the backlog, many cases were referred to mediation and parties were expected to show up. And I was dealing as counsel in a very complicated construction dispute. There were 7 parties. And when I got the notice, my first reaction, to be honest, was this is going to be a brilliant waste of time. Because it is a complex case, there are 7 parties, it's not going to be possible to have this resolved. Anyway, we had to go through the attendance. We showed up, and the mediator was not a lawyer, he was an engineer. And he started the morning by serving coffee and talking to all of us and asking how we were. And I was thinking, how much time is this, being wasted? Well, I tell you what, I became a convert because by midday the next day, the case was settled. And he had got around working one party at a time. And it was that skill, that human interaction, that showed that these kinds of seemingly intractable problems were capable of being resolved. Justice Call's story of the case before Justice Sikri is a beautiful story, again, illustrating the power of mediation to transform situations. So many lawyers went through that experience, and I think at the end of that experience, slowly they too were converted and saw the value of mediation as a real proposition. And then the next thing was we started seeing that mediation was actually remarkably successful. I mean, when you think about it, 70% of cases being resolved. Which method of dispute resolution can you get that kind of outcome at a fraction of the cost? I mean, most cases are resolved within a day. And you begin to see that actually this is not just an alternative method, it's a highly effective method of dispute resolution. And all the other benefits we both spoke of, you have lower cost of compliance, parties go away feeling happy. I want to read to you something that was written by an academic in Singapore reviewing mediation in the family context. And it's just 2 sentences. I want to read to you because I can guarantee you nowhere else in the dispute resolution world will you get this reaction. She wrote, research has shown that satisfaction ratings for mediation are unusually high and that participants generally perceive the mediation process and its outcomes as fair. Importantly, 93% of family mediation clients in one study said they would use mediation again. Anybody who's gone through litigation says, never in this lifetime, never again. Anybody who goes through arbitration, the same thing. Next few lifetimes, I don't want. But in mediation, people said, sure, this is a sensible way to resolve it. And we started putting the word out that this was actually not just sensible, effective, but actually it was good for people's state of peace in their relationships and with the justice system. And then I think the last point I would share is the emphasis on gradually getting to a stage where we started putting more and more emphasis on the skills of mediation and the standards of mediation and actually professionalizing mediation as a practice area. And we're still, to be honest, behind the curve on that. I think for our profession, I don't think we have enough real specialists who do nothing but mediation. But it is growing, and we have, through the promotion of accreditation standards, I think seen much wider acceptance and this raising of standards, which is all going to be integral, I think, to the success of mediation. So those would be some of my perspectives.
Thank you, Justice Menon. That's a lot of takeaway for us. I'll just go back to what you said about the first stage that in Singapore you started with the courts. And my next question would be to Justice Call. Sir, your leadership has been exceptional. We all know. If Justice Menon has been a rock star, you have been, for us mediators, a contemporary hero. And you've led the way in so many ways. My question to you, in the context of what we have just discussed and what Justice Menon spoke about, the role of judges and we all know his own role in the evolution of mediation in Singapore. In your view, can a judge change or improve the ecosystem of mediation? And in that context, how do you see the future in India of mediation?
I do believe that the judge has a very important role in all this. After all, we were trained as litigators, including me. It's not that we were trained as mediators. We did not know of mediation earlier. But if you see intrinsically, all of us are born as mediators if you look back. We are born as mediators because we mediate among small things in the home. We mediate between family members. We mediate so many aspects of life. It's a question of giving due importance to it. And I think the focus, as was being explained, arises from the court itself. Somewhere it has to be emphasized there is an element of futility of a litigation system because we'll fight, maybe get a little more of it. But by the time you get it, it's going to be a lot of time. And secondly, you will spoil your equations. That's why the issue of business and family members, etc. I still believe you have a lot of communities in India where mediation settlement is a rule, may not be a formalized mediation settlement. There are business groups, community groups, where you don't go to court till you make an endeavor to sort out this problem. When I travel through, there is people who feel that something must be with the court, and then only they'll go to mediation. That's how it began. That's the initial faith. So you had the institutional mediation playing a role, still will play a very important role, I think. But the transition must slowly take place from that to an ad hoc mediation. I know judges work, but then the judge in a way is taking from his time of adjudication to mediation. If the legal fraternity comes forth more importantly and they play a more greater role, you will have the lawyer who's litigating turning into a mediator. That's the ultimate objective.
Yeah.
The process may begin with this institutional mediation. But I believe the private mediations have their own role to play, especially in big commercial disputes. So the Chief Justice Menon was talking about the requirement of transition from huge arbitrations to big mediations. Well, the lawyer can make a good buck out of it and find a better solution out of it. The only way I feel the lawyers will slowly shift to part-time or full-time mediation.
Justice Menon, in India we have a Commercial Courts Act which mandates mediation. And as you pointed out in your speech, even in Singapore, there are certain areas which mandate mediation. Do you think mandatory mediation is a step forward? And is that the way to move forward? Or do you think there'll be a little bit of resistance? Or it's just a sham which will happen?
I think, if I may say so, I think that's a really difficult question. So let me go back and make the point that we didn't start mandating anything. We didn't do that. We started by introducing it as part of our system, putting it as an option, encouraging people to try it. But we didn't initially mandate mediation. And I think that we only started mandating it even today in some areas because the case is so overwhelmingly strong and because there's a high level of acceptance. But I don't think that necessarily means you shouldn't mandate. And let me explain why. The goal must be to reach a stage where when a dispute arises, people think of mediation up front as one of the options. That should be the goal. We're not there yet. So 9 times out of 10, when a dispute arises, the first thing people think about, certainly in our century, in the last 50, 60 years, the first thing people are thinking about is litigation or arbitration. And because of that, when you start talking about mediation in that context, you're talking about introducing a different modality of settling the dispute to parties who are already locked in a very adversarial stance. They're already caught in that battle. And there's a lot of resistance to changing course and a lot of fear that changing course may be interpreted as a sign of weakness, loss of face, lack of appetite, and this may be taken advantage of by the other side. All these are irrational, but they are there and often fueled by advocates, I have to say. So to overcome that, mandating mediation can be very helpful because it's a force that comes from a different place that says, go and try this. And the experience across the board, not just in Singapore, but I think across the board, where mediation is put on the table, the experience has been that generally there's a very good chance that you will get some outcome. That's, I think, the case for saying we should have some consideration given to mediation, to mandating it. But I think it is I'm not sure, because the danger with mediating it is also that if there isn't already that sense of acceptance, people go through the motions and they say, okay, I've done what I can, now I can go ahead and carry on with the business of litigating. So I don't have an answer for you, but what I can tell you is that we did it gradually. But I do want to make the point that where you do have a provision for mandating mediation, you've got to be absolutely certain that you have the infrastructure in place to try and make sure that those people who are forced to go and mediate will have a good experience. That means having enough mediators in place, trained mediators, and people who can actually cope with the flow of cases that are coming in. Because the worst thing in the world would be to mandate mediation and find that it gets stuck, and then you create a new source of disaffection, I think.
To Justice Menon, taking cue from what Justice Kaul said about the number of trainings he has attended. I have counted. I made a mistake last time, not 15, but he has attended 16 training sessions, both preliminary and the advanced training. And what has characterized, Justice Menon, your leadership, your judicial leadership, is that you have always insisted on the quality of mediation, including the quality of judicial mediators. You made a point here in the Supreme Court when you spoke about competence and legitimacy about it. I wanted to ask you whether this really impacts the quality of mediation. Does it really also impact the environment of mediation? This being very, very particular about the kind of quality that a mediator possesses.
I think it does. I think it does impact it. First of all, I think we tend to be in an environment where I think the majority of people who try to offer services as mediators tend to be lawyers or judges. And I think it's very important to remember that however sensible and commonsensical these people may be, I think it's very important to remember a point that Justice Kaul made, which is that the skill sets are fundamentally different. A litigator or a judge is primarily driven by the forensic task of trying to figure out what happened and who's right and who's wrong. And that's not the interest of the parties in a mediation. So the skill sets are fundamentally different. And I was fortunate to be exposed to that realization very early in my career, because in 1990, as I said, when I did a course in mediation, a university-level course in mediation when I was doing my master's in the States, it really was an eye-opener, because I'd never appreciated that this was such a dramatically different set of skills, and that you were looking at interests, and you're looking at value propositions, and you were looking at all kinds of benefits to be had if you didn't expend yourself in litigation, instead of looking from a perspective of trying to get redress and reparation through a legal process. And how you get there is fundamentally different, because a mediator is not really that fixated on trying to figure out who's right and who's wrong. So it was through that process that I actually began to appreciate early in my career that the skill sets were fundamentally different. And then when I encountered mediation as a lawyer, those initial experiences working with mediators who used completely different skill sets. Again, wonderful examples given by Justice Kaul, telling the brothers, go and have a cup of coffee before you come back before me. Simple things like that are just not the things that lawyers or judges would be having uppermost in their mind when they're confronted with a dispute. So I do think that there is a huge amount of benefit to be had in teaching people and inspiring in them the desire to learn how to do things differently. And that's not a bad thing, because we need to keep mediation as a different value proposition. What we're seeing in the world today is the legalization of all sorts of issues, and people come to court trying to get all sorts of results and outcomes by legalizing the issue into a legal question that they can get a ruling on.
It's a very important
Mediation puts you the other way. It delegalizes the issue and says, let's look at this as human beings and figure out what's the best thing we want to do as human beings in this situation. And it's so promising if we can get people to look at issues in that way. And
the public faith in litigation is driven by an intellectual interaction of ideas in the open. That is how it is acceptable to the public at large. The delivery of justice delivery system. In the process of mediation, it is a process of dialogue between the two parties. The mediators facilitate. The standard of intellectual interaction is not there because the two parties are situated on the platform of an unequal bargain. How can it be publicly driven on a yardstick, on a principle like the litigation, where the interactive ideas they play a vital role for sustaining the public faith? What measures are there?
So, shall I take that? Just for the benefit of those of you who didn't hear, the question was this, that the legitimacy of our legal systems depend on transparency and the fact that what happens or what is argued in legal cases are done publicly, and the public can see what is being said, can follow what is being said, can assess what is being said, and therefore confer upon it legitimacy, whereas in mediation, it takes place in private and it's concerned solely with the private interests of the parties. My response to that is the following. I think we need to ask ourselves, what is the purpose of the justice system? The purpose of the justice system is ultimately to resolve disputes that arise as an incident of everyday life. If we lived in a perfect world where there were no disputes, I don't think somebody would say, I think we need lawyers. I think we need judges to give ourselves a better life. I don't think that we should make the mistake of thinking that we as lawyers and judges are necessary for the good health of societies. We are there because disputes are a function of life in societies. In the same way that doctors are there because disease is a function of life in societies. They don't have an inherent right to be there. And why do I make that point? I make that point because once we realize this, we open ourselves to the insight that the first and most important thing we're looking for in the rule of law, in a successful justice system, is the opportunity for people who are caught up inevitably in these disputes to find solutions that they can live with and that are ultimately good for them. And if they can do that over a cup of coffee, if they can do that over a conversation in the chambers of the judge, and being invited to see the business opportunities that are available to them by resolving it, I don't think that that is something we should avoid. I don't think that is something we should avoid. So what we should be doing is sensitizing people to what the real purpose of mediation is. Now, the reality of life is, I can guarantee we will never come to a stage where mediation becomes the sole method of dispute resolution and litigation and arbitration fade away. That'll never happen. The real point I am advocating, and I think Justice Call is advocating, is that we need to open our minds to seeing that each of these methods have a vital role to play, and they are especially powerful for different types of cases. I completely agree with Justice Call. If you're dealing with a constitutional question, you don't want to mediate that. You actually want a statement where all the intellectual and policy arguments can be canvassed and resolved. You absolutely want that. And in many cases in our court-annexed procedures, once they see a public law question that needs accountability, they will not put it down for mediation because that can't be the way you resolve these questions. So different types of disputes have different types of interests. But if you're dealing with a private dispute, if you're dealing with a family dispute, a community dispute, a business dispute, does society really have a bigger interest than the parties? I'm not sure that they do, and I don't think that they do. That's my take on that.
I would agree with Justice Menon See, sometimes we tend to assign a greater role to ourselves as judges and lawyers than the society needs. The law and we are needed because the society should not go into a conflict.
Yeah.
So the purpose is avoid a conflict in society. That's the fundamental purpose of existence of lawyers and judges. Otherwise, people will be onto the streets to decide. If we can do that by any other methodology,
Exactly.
we have been mentally geared to, I think that everything must be adjudicated through court process. Mediation can resolve most disputes. Yes, they cannot. Suppose there are criminal ramifications. There have been issues. The panchayat tries to intervene in strictly, which has say a rape case. There have been examples in India where the so-called mediation of panchayat takes place. These are unacceptable because there are certain norms of society which must be played out in the court. Constitutional questions, serious criminal offences. But yet, if two people fight and there is a hurt given to one to the other, can't these people resolve the disputes even there? Murder cannot be resolved, but a hurt can be resolved.
Yeah.
Because the whole process, I think there's a greater hurt in the process that goes on. Only thing in India we have to be, I think, which is slightly different is, for a mediation, one of the parties invariably looks to the time period which the litigation will take. And even if he has a weaker case, in a compulsory mediation, he may try to adopt a path of little deviant path because he thinks he gains by the litigation. We have to bring a system where litigating should not be a gaining factor.
Yeah. One common question to both of you. That is, I think one of the main challenges that has been identified is the change of mindset of the lawyers or the change in the ecosystem. In the law schools in Singapore, I am told that mediation is an optional subject which is available. In India, it is the alternative dispute resolution mechanism which is an alternative subject, with mediation being one of the parts of that. But there is no, as such, a subject which is available in mediation per se to study. Do you think if mediation is taught in the law schools, that will help in changing the ecosystem? And because we have a large number of students who are present also. So, should law schools be doing a little more in relation to promoting the cause of mediation? And would that be helpful?
So my perspective is absolutely. I think the law schools can play a vital role in socializing future generations of lawyers to the value proposition of mediation. And one issue that I personally am deeply passionate about is this. You know, when we think about the justice system, when we assess the health of the justice system, we do so by reference to the cases that are brought before a court or cases that are brought before an arbitration institute. We look at those statistics and we think to ourselves, how well is the justice system doing in terms of clearing those cases expeditiously, efficiently, and so on and so forth. I think the real challenge in the world today is actually this. What we see in the courts is an iceberg. It's the tip of the iceberg. And an iceberg has as much as 90% below the water that's not seen. And I think that that analogy helps us to understand the real issue of access to justice today. The real issue of access to justice today is the large number of cases that never make it to the court because of expense, because of time, because of all kinds of obstacles. And if we can socialize people to the idea that you can resolve disputes in a sensible human way through tools like mediation, I think you would make an enormous contribution to advancing access to justice. And I think that promoting the awareness of the power of mediation and of making people aware of the different value propositions that mediation brings through law schools is therefore a hugely beneficial tool. And I would strongly support. So,
I would completely agree. See, this is where the base is laid.
yeah.
If you teach them that the only way the society survives is by litigating, without giving the option of learning about mediation, it brings a different mindset. Then you are trying to demystify that mindset and tell them, look, this is also possible.
Yes.
But if you, from the beginning, give this as a possibility, I think their understanding will be better. See, today, let's look at National Legal Service Authority, NALSA. So many paralegals who play a role in solving the small problems of people before it gets into litigation. Why is that a success? Is the concerned persons who have these small disputes really interested in knowing how many pages we write, what kind of law we laid down? He's concerned with his small problem. Therefore, you have to attend to those problems. That's why the role of NALSA changed over a period of time. Attending to these people at a smaller level through what is informal mediation, trying to be a bridge between the problems and the government. So I think if we have a more educated youth who understand mediation better, their role as lawyers will acquire a different nuance when they litigate, and they can choose between the two. Don't we have examples? Often it's not that the best of litigating lawyers, in my experience, have necessarily turned out to be good mediators. They may be so. There are many people who are not really doing so much of litigation and have done a wonderful job as a mediator. Different skill sets, as Justice Menon said. Yeah. So let the student know what is available and what skill set he has.
Perhaps our last question for both of you again. And I come back to quality and accreditation. Now, as mediation grows, there are going to be more and more practitioners of it, both in Singapore as well as in India. Now, in Singapore, you have the, as you said, Justice Menon, the Singapore International Mediation Institute, or SIMI, that accredits mediators. But SIMI doesn't train, from what we understand. Now, here, whether it's Samadhan or MCPC, we train and we issue certificates. So my question to both of you is, do you think there should be a uniform standard throughout the country that ensures quality, and how do we do it?
I'll take the question first so that he has the last word of it. I believe Singapore and India are a little different in this context. The nature of litigation in Singapore is different from the litigation in India. We are from very basic litigation to complex litigations. Therefore, the skill set required to settle a dispute at a municipal level is not the same skill set which is required to settle disputes in high commercial matters. And therefore, even if there is no perfect arrangement of training, as long as we have mediators who have the skill to determine and settle disputes at the base level, it is important. After all, lawyers don't have the same skill set. Can we say that despite the Bar Council that every lawyer will have the same skill set? If that doesn't happen, and depends on which area they are operating in, at which level they are operating. Training, yes, necessary. Abilities, evolution necessary. Merit necessary. But I don't believe the same kind of skill sets are required at different levels throughout the country to have a successful mediation in the Indian context.
I actually agree. Despite, I mean, I'm not sure that we're that different. We're much smaller in Singapore. But we have a similar range of the types of disputes. But I think I come to this from another vantage point also. We've talked today at length about the big divide or dichotomy between adjudication and non-adjudicative processes. But the other big dichotomy is between state-provided methods of dispute resolution, namely litigation, and private means of dispute resolution, arbitration, mediation, and so on. And in the years that I've been involved in the field, trying to drive reform in areas like arbitration, for example, the thing that I found is that there is an almost irresistible urge on the part of private sources of these services to say that it should be driven by the market. You should let the market develop those areas. And I think it would be unrealistic and perhaps unwise to try to mandate either a common standard or a common approach or a common set of tools. And my own view is that as we look at how mediation has developed in Singapore, one of the things we have realized is there are many distinct areas for mediation services, many distinct types of mediation services, and each of which would benefit from different types of approaches. The sort of approaches that a family mediator would bring to deal with a pure family dispute might be quite different from the sort of issues that a commercial mediator would bring to resolve a commercial dispute. And therefore, it might be unwise and unrealistic to try to strive for a common standard. And instead, our focus should be on on educating people of the need for training, on educating people for the value of training, but letting this process grow organically in response to the needs of the particular areas in the market where mediators are needed. And I think by doing that, you will allow it to grow at its pace and with its particular focus. And I think over the long run, you will get better outcomes. That's, I think, my sense as well.
So we thank both of you for this wonderful session.
Thank you. Thank you. Thank you so much. Thank you.
Thank you. Thank you very much. We'll take a break for about 10 minutes.
Yeah, 15 minutes because, and we will assemble again after 15 minutes. Thank you very much, sir. We are grateful to Honorable Chief Justice Singapore, Mr. Justice Sundaresh Menon ji.
Thank you. Thank you.
And Honorable Judge, Supreme Court of India, and also Executive Chairman NALSA and Chairman MCPC, Mr. Justice Sanjay Kishan Kaul ji, with a huge round of applause, ladies and gentlemen. Please extend your gratitude to both the speakers, and we are thankful to Honorable Mr. Justice Manmohan, Judge, Delhi High Court and Chairman Overseeing Committee, and also Sadhna Ramachandran ji, who moderated this session. Please join us over a cup of tea, and we will meet again after just 15 minutes. Thank you very much.
What time do you have to be with the chief?
Sorry?
What time do you have to?
He said somebody will come and get me at about 12:45.
Okay.